Ready? So good morning. Thank you for being here. Back in 2018, California created a mental health diversion program to help those who actually needed treatment, especially for low-level nonviolent offenses. That was the intent of the bill. But that's not what's happening today. Right now, the system is being used by violent and repeat offenders to avoid accountability, and people are paying the price as victims. Right here in Sacramento, we've seen cases that should outrage everyone. Some of the displays here reference those cases. A 1-year-old baby beaten to death, and the father gets diversion. A 3-year-old poisoned, abused, and locked in a filthy room, and the abusers walk away with diversion and no charges. A toddler beaten so badly he died with nearly 50 injuries, and the parents tried to use diversion to escape responsibility. This is just a few. This is not rare, and it's not hypothetical. This is happening right here in the state of California. And people are asking, how is this allowed? It's allowed because the law doesn't have clear limits. It leaves too much room for abuse, and bad actors are taking advantage of it. And law enforcement sees this every single day. We have a deputy district attorney here from Placer County who will tell you that this is not a one-off problem. It's happening over and over again, and right now there aren't enough tools to stop it. And that's why we're here. SB 1373 fixes this broken system. It gives judges the authority to deny diversion when someone is clearly in danger to the public. And it makes it clear that if you commit the most serious, violent crimes, diversion is not an option, especially if they're against children. However, this bill still protects access to mental health treatment because some people really do need mental health treatment. If you truly need help, you should get it. But if you don't, and you hurt people, and we have victims, like I said earlier, especially children, you don't walk away with no consequences. That's the purpose of this bill. That's not justice. That doesn't provide justice to victims. This bill restores balance, it restores accountability, and it restores trust in the people that elect us to serve them. I'd like to introduce my colleague who is kind of my right arm on these protecting victims bills, Susan Rubio, a senator that I deem highly respected. Thank you.
Good morning. I am State Senator Susan Rubio. I represent the 22nd Senate District in Los Angeles County. First of all, I want to thank the great senator from Bakersfield, Shannon Grove, for her partnership. As she already stated, we have partnered on many bills to ensure that victims get justice and our communities are safe. I'm proud to stand alongside her once again. In the first round of partnership, we focused on bills that protect victims of human trafficking. SB 1414, that strengthens California's response to human trafficking and makes it very clear that those who harm our children will not get away with it and will be held accountable. As a victim's advocate, this is critically important to me, and that is why I'm here standing firm as a co-author to SB 1373. Let's be very clear. Mental health treatment matters, but details also matter. Diversion has an important purpose. It's meant for people who need treatment, not for those who pose a risk to others. But public safety must also remain part of the conversation as we make these decisions. When the system is too broad, when it lacks clear guardrails, and when victims and communities are left carrying the consequences, it is our responsibility as legislators to fix it. This bill makes clear that mental health diversion should not be available in certain serious cases, including specified child abuse offenses, human trafficking, and other violent crimes. We already heard the great senator give examples of children horrifically harmed, and that must not stand. It also clarifies that standards courts use when deciding whether someone is suitable for diversion, making clear that persons must not pose a risk to our communities, and everyone needs to feel safe. This bill also recognizes something that victims already know too well. Again, that those small details matter. A person's prior history, the level of violence involved, the seriousness of the offense, and the severity of injuries to the victims matter. We can believe in treatment. We can believe in rehabilitation, as already stated. We believe in offering help to those that need it. As legislators, our job is not only to create opportunities for intervention, but also to make sure the laws that we create don't have any loopholes that put public safety at risk and deny justice to victims. Victims have already endured enough. We also need to lead with them in mind. Again, I'm proud to support SB 1373 because it reflects that balance. It says that California can be thoughtful, compassionate, and still firm. To all victims, we want to say, we stand with you. Thank you again, Senator Grove, for this opportunity to partner once again to ensure that our communities are safe and that we lead with victims in mind. Thank you.
Thank you, Senator Rubio. Right now we have Sergeant Seidel from the Sacramento County Sheriff's Office, who's been with us since the beginning of this challenge to help protect victims.
Thank you, Senator. So from the Sheriff's Department point of view, I would just go ahead and say I would like to really bring it up. I would really like to talk about the victims in this particular case. And I know the senators have mentioned that as well. Because of my position where I'm at, I deal with victims on, frankly, a daily basis. For a year and a half, I was the supervisor for our felony assault unit, which included domestic violence, stalking, and violations of court orders. Learned a lot about family violence in that arena. And for the past 4 years, I've been the supervisor in charge of child abuse, physical, sexual, as well as child homicide. And I can tell you from those perspectives, this particular law as is very, very damaging, and it's a long-term problem. One of the issues that we have is that we cannot forget that the victims of these particular crimes, as horrendous as they can be, it is not over for them within a couple years. It may not be over for them for 10 years, 20 years. The rest of their life, they're going to be thinking about this. They're going to be dealing with this. Yesterday, I had the honor of attending an adoption ceremony in court for one of our child abuse victims, who will remain nameless at this point. Both of their parents mom and dad are both in the Sacramento County Jail facing severe child abuse charges. And yes, both have applied for mental health diversion. The decision has not been yet made by the court, but the fact that both of them are eligible to begin with and considered suitable, based on case law and history, it looks like there's a decent chance that it would be hard for a judge to truly deny them the opportunity for mental health diversion. I bring up this child, who's 3, because this is more than a year since we were called out to work on this case, and this child is still having long-term medical problems, still has a gastric tube, still has some concerns for her psychological health due to the severity of the abuse. When I point this out, the sheer audacity that the parents potentially could be granted mental health diversion, go out of custody, continue their treatment, provide adequate completion to the court, and then it's as if the entire arrest never happened, pursuant to California law, existing law. So in 2 or 3 years, it is off, it is gone, it is as if it never happened. But for the child, she's going to have lifelong medical and psychological problems because of their behavior. And so to have this just completely disappear is beyond outrageous. So these are some of the examples of some of the other cases, as the senator has pointed out. Again, these children are also going to have lifelong problems. And for their abusers to go to a treatment program, get it signed off, and then everything is simply erased, and they can go on to work in a daycare, coach Little League, and so on, is really beyond the pale. So thank you for your time, and I'll give it back to Senator Grove.
Thank you. Thank you, Sergeant Seidel. I appreciate that very much. The next person that we're going to ask to come up and speak is in a way, a victim herself as a mother who wanted to protect her children, who always told her children, tell the truth, be honest, and you'll be protected. And that didn't happen when her kids come forward. This next person has the courage of a lion because she is a mama bear that protects her children, and she's doing everything possible to bring awareness to what happened to her family while still protecting her children from what could happen in the media sense. And I just give her the biggest praise ever because she does a well-balanced job in doing this. Christina Scrivener.
Thank you, Senator Grove. Good morning. My name is Christina Scrivener. 2 years ago, my family's life changed forever. And today, I stand here urging the passing through the committee of Senate Bill 1373. Mental health diversion must protect innocent children, not allow their perpetrator to have a record of abuse wiped clean. In my family's case, mental health diversion offered therapy and medication to a man who already had been attending regular therapy sessions and on antidepressants the night he assaulted his own children. 2 years ago, Zach Scrivener went to work, attended a televised Board of Supervisors meeting as a sitting supervisor, and ironically presented a resolution for Victims' Rights Week to District Attorney Cynthia Zimmer. That evening, after that meeting, he went home and violently abused his children. The California State Attorney General charged him with 5 felonies, 3 of which detailed the abuse of his children. The court granted mental health diversion, the precise therapy and antidepressants he was on that did not prevent him from committing heinous crimes against his own children. If those methods didn't prevent him from harming his own children, how will mental health diversion prevent future crimes in this case and in so many others that we're hearing about today? Children deserve a chance for Senate Bill 1373 to pass.
Thank you, Christina, again for your courage. The next individual that we have to testify is also someone who's very courageous in our community, and she does immeasurable, successful work with victims, and she's very successful in making sure that they have an opportunity to grow and thrive. And I'd like to introduce Lauren Skidmore at the Open Door Network.
Thank you, Senator. My name is Lauren Skidmore, and I am here today to urge support of Senate Bill 1373. My organization supports victims and homelessness, seeing thousands of people in need and advocating for strength, safety, and peace. I have personally sat with survivors of assault, survivors of trafficking and abuse, whose perpetrator went through this program and walked away with a clean record. Those survivors did not get a clean record. They carry what happened to them every single day. Under current law, individuals facing charges of serious crimes such as child abuse and human trafficking can access mental health diversion and avoid real accountability. That is not what justice looks like. We know the impact and importance of second chances, yet second chances should never come at the expense of a victim. April is Child Abuse Prevention Month, and children deserve a safe and peaceful childhood, free of this, free of having harm without accountability of their abuser. I support SB 1373. Thank you.
Thank you, Lauren. Next, we have Tiana Herrera. Tiana is a dual licensed LMFT and LPCC therapist specializing in mental health and fortitude for the first responders, military members, and veterans of their families. Please welcome her.
Good morning. I'm Tiana Herrera, a dual licensed mental health therapist specializing in trauma. The mental health community has worked for decades to break the stigma around mental health. We fought to ensure that people struggling are met with empathy, understanding, and access to care. However, I am here today because we are at risk of undoing that progress. The current mental health diversion program is structured in a way that allows it to function as a loophole for defense attorneys and offenders to bypass accountability under the pretext of mental health. To be clear, mental health disorders should never be exploited as a legal pretext for individuals with antisocial personality disorders, nor should subjective self-reporting be utilized to circumvent accountability for criminal conduct. This exploitation degrades the clinical integrity of the diversion program and results in the devaluation of legitimate mental health treatment within the judicial sphere. Protecting the diagnostic integrity of mental health needs is essential to ensure they are not utilized as a loophole to rationalize or mitigate antisocial conduct. In clinical practice, healing does not begin by eliminating consequences. It begins by helping individuals understand the relationship between their choices, experiences, and the impact and repercussions of the choices on others. Diversion frameworks need to be anchored in trauma-informed care and evidence-based parameters, ensuring the process is intentionally designed to help those truly in need and not to be exploited by bad actors. I thank Senator Shannon Grove for continuing these vital discussions in the state legislature. Now, I call on California leaders to take a hard look at how these policies are being implemented and to establish a new baseline where empathy and accountability work together, not against each other. When diversion programs maintain this baseline, they protect the individuals who need treatment, preserve public trust and safety, and ensure that mental health care remains what it was always meant to be, a path towards healing, not a loophole in the justice system. Thank you.
Thank you very much. And the last person that we have here that's going to give us a little bit of testimony is works for District Attorney Morgan Geyer out of Placer County. Please welcome Deputy District Attorney O'Hare.
Thank you, Senator Grove. I'm here to support SB 1373. I'll be speaking in the committee about my experience as a deputy district attorney who litigates these petitions on a near daily basis. And what SB 1373 would do is it would give us the tools we need to actually put up meaningful guardrails on mental health diversion, because right now it's something of a free-for-all where defendants will go in and seek out a diagnosis from forensic psychiatrists who they haven't ever spoken to before they were arrested. And once that diagnosis is made, it sort of sets into motion the steps needed for mental health diversion. And we as prosecutors don't really have any meaningful tools to stress test the quality of the evidence that is brought forth. So I look forward to speaking to the committee today. Thank you, Senator Grove.
Thank you. We'll take questions if you have any, and then we're going to go into committee and present our bills. No questions? Yeah. Yes, sir. Sorry. Yes, sir.
Alluded to earlier that they receive therapy and medication. What are the details, Senator Grove, that this diversion offered, these type of people who seek out this type of remedies?
So when the, and I'll allow the assistant district attorney to respond as well, but when the initial bill passed in 2018, there weren't guardrails on the specific types of rehabilitation, diversion, therapy that needed to be done. So we actually have testimony that is a written testimony from a court case where there's a licensed marriage counsel therapist who has got mental health diversion for over 300 cases, and she just has to apply for it. When you listen to the calls that are going out from the Sacramento County Sheriff's Detention Center to family members, you have individuals saying, hey, I'm going to apply for this new thing called mental health diversion. It's just, in some cases, especially those that know how to circumvent the system, is a get-out-of-jail-free card. Did you have something else to say? Sorry.
Yeah, was your question about the treatment they receive?
Yes, the treatment and the medication that they give.
Yeah.
Go ahead.
Yeah, it really varies, and it varies from county to county. In Placer County, for instance, there's a treatment plan that's supposed to be put in place, but it's not really put in place until after diversion is granted. And once that treatment plan can look like a lot of different things. It can be residential in some cases. It can be something as simple as going to therapy once a week or once a month. Something very de minimis versus something that can be more intensive. And that's why we do advocate for mental health diversion for people who really need it and who have a treatment plan that's going to be effective. But when there's not really a treatment plan in place and it's just sort of go to these meetings once a month, that doesn't really meet the intent of the bill or of the intent of the diversion program.
And back to, just in reference, for a perfect example in Kern County District Supervisor Zach Scrivener went to work, as Ms. Scrivener just testified. He was taking medication, antidepressants, and he was seeing a therapist. He assaulted his children. There's 5, I believe, felony counts against him. Assaulted his children that night when he got home, and then he got sentenced to mental health diversion programs that require him to take antidepressants and get mental health counseling. The same medication that he was taking and the same therapy that he was doing when he went home and assaulted his children. We need guardrails on mental health diversion. We're not saying people don't need it. Yes, yes.
I'm not an attorney, and I'm not an elected state senator, and this was all very new to me. And I think one of the most shocking things that people don't understand is this all happens in advance of a court of law seeing the evidence laid out of what happened. My children and other children don't even have the opportunity to present in the court of law what happened to them before this is triggered. And I know that was not specifically your question, but I think it's important to understand that this is not a treatment once they've evaluated the situation. This doesn't provide any measure of justice in the court of law for the victims to even be heard.
Senator, I know it's a bipartisan bill, but any indication from the governor or any Democratic leaders on the future of your bill?
So we have met with the public safety chair. We understand that with the committee analysis and the amendments that we took, there is an aye recommendation, but there's also other members on the committee that may not follow the chair's recommendation. We're hoping that we do get the votes out of committee today once they see all the evidence. And just to reiterate what Mrs. Scrivener said, this is not a program that does not allow people justice in the court system. This is allowing the repeat offenders, individuals who violently assault children or assault children, we're focusing on our kids, and that all can attach themselves to this DSM-5 list that has over 350 measures that you can be, diagnoses that you can be given mental health diversion on. And if you read this list, it's atrocious. But the whole point is that we give victims an opportunity to at least present in court. Like Ms. Scrivener says, which is a very point well taken, is that these individuals, Zach Scrivener was not arrested, was not arraigned, convicted. There was no court process. Along with the parents and the individuals and the adults that harmed these children that are up here on this board, there was no court process. The victim's advocate didn't get to say, this is what happened to these children. They just automatically get it. They're detoured from court. They go to the mental health classes that are prescribed by the judge, and then they have a clean bill of health. And all these people can adopt children. There's no record of anything that ever happened to them, and the records are sealed. Correct? Correct.
We have one other question.
Sure.
Deputy Seidel, if you don't mind. How do you see these type of cases, these heinous type of cases, with individuals who may, get therapy and get the medication? It seems like they're making them more hyperactive. But how many times do you see these type of cases?
How many times do we see cases that are similar to this? Well, we see, as far as physical abuse and severe physical abuse, it's probably, close to a fifth of our caseload as it is. So we're talking just with my agency, at least a couple hundred times a year that we're going to see the severe physical abuse. We're not even talking about the misdemeanor level or even some of the neglect cases without serious injury, which all of them are eligible for diversion as well. So we're going to see a couple hundred of these. Sacramento Police Department, Folsom PD, Elk Grove PD, they're also going to see some of these more severe cases. And to see, I want to make it clear, that Sheriff Cooper, while he supports this, he also supports the concept that this is not denying anybody mental health treatment at all. In fact, we think that it's better if they do. Our jail, sadly, is full of people who have significant mental disorders. We don't want to be the mental health facility for the county or for the state, but that's not what the issue is here. The issue is accountability, and it's a certain degree of justice for the victims, of course. So one of the things that needs to be kept in mind during all of this is perhaps it is best for some of the defendants to receive mental health treatment. That could be in their best interest, for sure. But that also has to be weighed with our California Constitution, Victims' Bill of Rights, along with public safety and people that are going to be living next door to and interacting with these suspects that, frankly, are not held accountable for their actions. That answer what you're...
Had therapy, medications, do you get those type of reoccurring cases that has something to do with child abuse?
The short answer is not exactly, in part because the law passed in 2018 wasn't really used much until probably 2020, 2021, so we're still at kind of the front end of it. Our friend here with Placer DA, he might have a different perspective, but as far as it goes with us, now some of the defendants in cases like this that receive mental health diversion go on to commit other types of crimes. If we are lucky, CPS and the child welfare system has removed these children, which has happened in these cases. The children have been removed, and they may not be adopted out. They might still have some limited visitation with parents and so on. So there's a bit of a delay that goes on with that. So we are seeing them commit other crimes, these defendants. They haven't yet committed additional crimes against children, but they also have a very limited access to children at this point.
There's a report, just to give this, and I'll provide you with this. There is a report out here that starts out, diversion's dirty little secret, defendants have a higher recidivism rate than those that are not. The report and the data in this, there's a graph on table number 11 that says that after 1 year of with new arrest, after 1 year, basically on behavioral health, 41 recommit crimes. Community support issues are 42, 38, 25. I can give you all this information, but the report does show that these individuals are committing crimes. And then we use an example when we go to Public Safety Committee of an individual who beat someone, stole someone's possessions, an elderly man's bicycle, and then got diversion, crawled into a window of a little girl's bedroom, slept in her bed. Thank God the child was with her mother, and then he got arrested again, got mental health diversion. And when he got out and was on mental health diversion for the second time, he climbed into a window, broke into a house, and he murdered the woman as she bled at the end of her bed, bled out at the end of her bed while he was sleeping in her bed. So those are not outlier cases. These are not outlier cases. When the opposition comes and says these are minimal cases, one case is too much, but only in Sacramento County, they've already admitted that 200 of their cases are roughly what we're talking about today, and it needs to be stopped. This simply says if you're a repeat violent offender, if you have already been sentenced to mental health diversion and there's a chance that you are a risk to public safety, that you can't get mental health diversion. It doesn't mean you're guilty. It means you go through the court process and the jury of your peers decides what happens to you. Thank you.